everybody. My name is Jessica Pierpoint. I recently changed it, so it was Taurus. If any of you guys have heard of me or talked with me in the past, you might have known me from that. We are going to talk about patent basics for new inventors today. So last week, if any of you guys came to my session, I talked about intellectual property, and I'll be focused more on trademarks next week. But this week, we're focused solely on patents. So hopefully you guys will find some information useful, maybe learn a couple new things, and I'll hopefully have time to segue into questions towards the end if you guys have any. You're also welcome to put questions in the chat throughout the session, and I'll be sure to look through those at the end and kind of answer some of those. So I work for Wichita State University at Avila Library on campus, and I'm the Information Services Research Assistant, but I'm also their PTRC representative. So a little bit about that is the PTRC program, or Patent and Trademark Resource Center program, began in 1871, and there is about 84 of us scattered throughout the U.S. USPTO is our headquarters, and they're in Alexandria, Virginia, and I am the only one in Kansas. So Avila Library, they became a PTRC in 1991, and we are the only location. We will hopefully begin a second helper, so I won't be the only one taking consultations and doing workshops and be the point of contact, but for now, a little while longer, it is just myself. So some of the things that we offer as a PTRC representative, I kind of want to start off with this, is we offer books and guides to help with filing applications. We also provide classroom instruction. Right now, that looks a little differently because of COVID, so we're doing mostly Zoom. We also offer workshops, such as this one. I do individual consultations by Zoom and by phone, also through email as well. Those are about 2 hours, and it kind of ranges, but that gives you enough time to kind of get the help you need. I also do outreach and display cases at our library to try to share resources. I also have resource guides that I will kind of talk a little bit about at the end of this presentation. And then, like I said, I do guides online. I help with a lot of various things, not just with patents, but also trademark, copyright, and any forms of intellectual property. This is kind of a picture diagram of where our USPTO PTRC brochures are located. So this is on the first floor next to our reference book section. And all those booklets are going to range from how to file a utility patent, a provisional patent, design, plant, just general information. I also have booklets on trademarks, copyrights, and just general forms of IP. I know I talked a little bit about books. We do have a small collection of books that are located on the 3rd floor of our library in the K section. And our most popular, especially that are going to pertain for this workshop, are our Nolo Press books. And those are written in everyday layman's terms, so anybody can understand the jargon because it can get really complex. We also have a patent application drafting book. We have books about patent law, inventors, invention, not just for adults, but also for young inventors, such as kids or teens. So just a couple of things to be aware of, some of the services that we offer at our library and that I offer to you guys as a PTRC rep. So like I said, this week we're going to be focusing mostly on patent basics. So we're just going to dive right in. So what is a patent? A patent is a property right granted to the inventor by the U.S. Patent and Trademark Office, also known as USPTO. It gives the right to exclude others from making, using, offering for sale, or selling the invention in the U.S. or importing the invention into the U.S. So today I'm mostly going to talk about the USPTO and how to get a patent through them. If you're looking at foreign, I'll touch on it very briefly, but that's a whole different segment. So today we're going to focus mostly on US, getting a patent here. Patent term, it does begin when the application is filed, if later issued. So obviously when you fill out the application, it's going to take a little bit of time to process, but they will backdate it from when it was filed. This can change due to subject to payment of maintenance fees, or FDA approvals could switch that timeline as well. So I'm just going to go right into it. There are 3 types of patents that I'm going to kind of go step by step in process. So utility is the first patent. This is about 90% of your patent applications. It has a 20-year time frame, so it gives you 20-year protection. This is going to be multiple things. So it can protect a process. This can be a series of steps, maybe a whole method chain you have. It can protect the machine itself. So I have a little example down at the bottom of a motorcycle. So it could protect potentially the mechanical device, maybe the combination, how it functions or performs. That's just a couple guesstimations on terms of that picture, what all it could obtain regarding a utility patent. It could also protect the article of a manufacturer, so the product itself, or the composition of matter. So if there's chemical components or physical features that might come into play, this could also be considered a utility patent. Now, there are also 2 other types of patents. They're not as prevalent, but still quite a few times I see a lot of these types of patents coming through. So the other 2 are design patents. So this can protect the oriental design or shape, maybe the appearance. For this example, I like to use a chair. So a chair itself can be a utility patent, but it can also be a design patent specific to the design itself. So this chair, it has a little desk area attached to it. It doesn't have arms, but it has a little desk. So that desk component itself can be considered a design patent. Quite frequently, I sometimes get people that ask questions in regards to potentially having multiple patents under their one invention. This can sometimes be the case with design and utility. There's also plant patents, and plant patents are considered to be a new and distinctive asexually reproduced plant. It also can be a type of tree, sometimes flowers. We see a lot of this more frequently, especially right now. I feel like a lot of people are getting creative in their gardens, but both of these have different year terms. So design has 15 years and plant has 20 years, just like utility. So that pertains to how long the patent itself can be protected. So a little bit about patent critiques. So when you're looking at a patent, you're looking at your invention yourself, you're going to think to yourself, okay, so is my invention, or is my whatever it is that you're creating, is it going to be patentable? So first you want to look at what forms of patents could it potentially be, whether it be utility, design, plant, maybe it be multiple, maybe it's a utility patent, but you maybe have 5 different components to it that could be each its own patent. So this is kind of a way to go down that checklist to see if your invention can be patentable. So you want to ask yourself 3 questions. 1, is it useful? So does it serve a purpose or works as it describes? And does it have a realistic use? Second, you want to think about, is it novel or is it new? It needs to have at least one new unique claim that differs from any other prior art. So let's say, or it needs to have some new physical change. So let's say you're creating some sort of new phone. Well, there's a lot of phones out there, but maybe your phone has some new or obscene claim that has never been created on any other phone before. That could maybe have a different dynamic to it. Phones are also a good example because they show multiple forms of patents and IPs in general. So like you see in that diagram, each of those numbers, there's different dynamics to which it is patented. Some it's the design, some it's the software behind it, it could be the process behind it, lots of different configurations. And then also you want to look at, is it non-obvious? So this differs from existing knowledge in any other way. So not only are you looking to create something, get something patented that's completely new, but it also needs to be kind of non-obvious in a way. And that can be a little difficult, but it becomes a process. So, okay, so next we're going to break down the parts of a patent. So I talked a little bit about what exactly is a patent, and you know, how there's different kinds, there's different terms for each in terms of how long it's protected, and also talked about what the criteria is behind it. So once you've gotten to that step of, you know, which type of patent application you're looking to do, whether it be one or multiple, maybe it's two different types like utility and design, and then you figured out, okay, it fits the criteria, it's something new, it's non-obvious. So now you're ready to go into that application dynamic. So this is going to be showing you parts of the application. I'm going to kind of take you step by step through it. So this right here is an example of what a patent application looks like. So as you can tell up at the top, it says United States patent. So this means that you are applying for a patent that is going to give you protection solely in the US. If you were doing foreign patents, or if you were doing multiple patents in different countries, then it would list something different. But like I said, we're just going to focus on US today. Off to the right-hand side or left, however you're looking at it on the screen, it will show you your patent number. So this is going to be your number that is associated with your patent itself. Below it, it will show the date of the patent. So this is going to be, like I said, your filing date. As long as your application goes through and it gets granted, it will backdate to that filing date. And that is when your 20-year term or 15-year term begins. As you look through under US patents, you will see the last name. This will be who the applicant is. Then you look at the inventor. If there's multiple inventors, there might be multiple names. Same with if there was legal help that was used, that might be mentioned throughout the application process. Then you look into, you see a lot of different numbers and a lot of different letters. So you're going to see the classification search. So this has to do with your prior art searching, as well as kind of other patents that are out there that might be similar to your patent, yet yours is still different in and of its own way, which you explain that through the application and the claims. Reference cited, this is where that would be. So as you can tell in this example, there are a lot of references that are cited to how those patents itself are similar yet different from your own. That's going to be something that the patent examiner is going to look at. That's kind of where their extensive training kind of comes into play. Then you see the abstract. So abstract is probably, abstract and claims are probably two of your most important things that you want to really take your time on when doing a patent application. So abstract is basically going to be your invention in words. It's going to describe what your invention is. A patent examiner, yes, they might look at the drawings, they might look at the sketches, but they should be able to read your abstract and know exactly what your invention looks like without looking at those drawings. This is why some applications don't necessarily have drawings shown. But this is going to be like the first thing that they look at, kind of see, okay, what is this? What are they looking at? And kind of go from there. Okay, so like I said before, these are some things that a patent application is going to have to fill out. So you're going to have your title, inventors or assignees, This can also pertain to if you have some sort of legal help as well. Your classifications and your references cited. So this can be related patents. It can be not only patents that you find, but also publications, writings about those patents. And publications aren't just in journal articles. It could be maybe a book cited. It could be some sort of site. There's lots of other things and other prior art. Then you're also looking at your patent number and your issue date. So this is something that will get assigned to you. It's not something you have to fill out right in the moment. And then you're also looking at the utility patent, design patent, or plant patent. So depending on which you're applying for, you might be putting down a letter. If there is a patent examiner, that will be put down. So whoever it is that's looking at your application, who you'll be dealing with, that will be put down. Like I said, the attorney, agent, or form, your abstract, and then there's your drawings. So next, I'm going to talk a little bit about prior art, because I know I mentioned reference cited, and this pertains to what prior art you might find. So prior art can be a lot of different things. It can be past patents that you found that could be similar to your invention, or have some sort of claim that's similar, yet yours is different in this way. And you'll have to cite that at some point. So you're looking at not only US, but also foreign, because even though it might not pertain to you, you want to make sure that you're still looking at what else is out there and that could be similar. Like I said, published patent applications, journal and magazine articles. You're also looking at books, manuals, catalogs, websites, databases, conference proceedings. This is a couple new things that people don't necessarily think about, but YouTube videos, blogs, social media, that counts as well. And any other public publications or public disclosures. This all counts as prior art. So when you go and you start searching for patents and searching to see if your invention is new or novel or things are out there, you don't just want to do like a Google search or search through the databases. You also want to look at writings. You want to look at videos, all those things. So like I said, in regards to patent searching, so this is how you would conduct a search. So you've reached that point where you're like, okay, I know my invention would be utility, or it would be design, or both, or maybe it's plant. I know it's novel and new, but I need to prove that. So I'm going to do a prior art searching. I'm going to search for patents that might be similar. So why do we do this? We do it to avoid infringing on other patents. Obviously, if you're infringing, you're not going to get your application approved. You want to find that out before you actually go through this work of paying all this money to apply and then not get it. Maybe you want to track competitors. Maybe your invention does have other platforms to which you might be competing with those companies. So you want to track that. You want to discover how new things work maybe. You're looking to prepare to file an application or discuss the ideas with potentially a patent attorney or agent. And then you also want to become familiar with the parts of a patent application. You want to kind of see the technical and the legal language. I showed you a really good example of a patent, but there's a lot of jargon on there. So becoming familiar with other patents that might be similar to yours, or patent applications, that can help you to kind of understand step-by-step areas of that application itself. So when you're looking for prior art searching, or you're looking to patent search, your best bet is to first look at just patents. Then you want to kind of expand, like I said, into those journal articles, maybe YouTube videos, maybe just a plain Google search. So these are some examples of where you would want to search for patents that are free. So obviously USPTO, they are a good source. They've got PatFT that you can search, and then if you go to PTRC locations, we also have a couple softwares, PubEast and PubWest, to which you can also do a thorough search as well. But USPTO, that's going to be where you would go if you want to search solely US patents. Google Patents is another example that I like to use, and sometimes it's a little bit easier to navigate depending on which search engines you tend to preference. Google Patents is different from Google. It's actually, you can tell the difference because it'll say patents underneath, like in the picture example. Google Patents not only shows you US patents, but it'll also show you foreign patents as well. The difference between it and USPTO is that, as well as if you scroll down to the very bottom after doing a search, you can see different charts and graphs to which it'll show the top competitor companies that are doing patents related to that search. Or maybe it'll show the top inventors, just different things like that. Espasnet is going to be your European patents. So if you're looking to apply outside, you're looking to apply for foreign only, this would be a good place to look. Maybe you also just want to see what else is out there foreignly, and instead of doing Google Patents, you want to do USPTO and Espasnet separately. Free Patents Online is another one that you can utilize. And then there's also WIPO, or WIPO, however you want to say it, the World Intellectual Property Organization. So they're going to be the ones that if you're looking to do multiple patents, not just in the US, but maybe you're looking to apply the same patent in other countries, they have a program where you can kind of do an application, and it helps you to fill out one for each of the countries you would be looking to get your patent done for. So I'm going to continue. So I know we talked a little bit about a patent example in terms of what it necessarily looks like, and you guys got to see most of that top front. So like I said, you're looking at what the title is. In this case, it's an adjustable desk apparatus. You see the applicant, the inventor. You see if there's like a notice, appeal number, when it was filed. You're looking at, and then you see where it was granted and what the US patent number gave. And then you see the references cited. So this has, a list full of prior art searches that have been done and that are similar, yet this is considered to be different. And then you've got your abstract. So like you see, abstract doesn't have to necessarily be very long, but it does show you and kind of talk, if you read through that, it'll really show you, okay, this is what the inventor is inventing. And reading through that, you should be able to tell without looking at the photo what the desk looks like itself. So next I want to talk a little bit about drawings. Like I said before, drawings aren't a must-have in an application. They are seen in most applications though. Most people have some sort of sketch or prototype or design and they want to show it from all angles. But the reason it's not required is because the patent attorney, they do look at it and they read the abstract first. And if they read the abstract and it's completely different from the drawing, or they decide, okay, I know what it is, they shouldn't need the drawing. So the drawing itself, though, can be an illustration or just diagram, like I had mentioned before, and it begins on the front page, and then it just kind of includes as many as necessary. So in this case, there's 3 examples, and you see the desks from different angles. There's also little numbers that are mentioned, and this will show and talk about different things. So this application itself, they're trying to show the differences from all different angles. And like I showed before, and then I'm going to take a quick water break. And then here are the other things that an application is going to include. So it might include background of the invention. It's going to include a summary of the invention. So yes, the abstract kind of is a summary, but this summary is going to go even more detailed, more in depth. That's where those numbers from the prior example really come into place, because you're not just showing examples and talking briefly about you're going into the full detail. So that summary is going to point out those numbers and describe each little aspect of your invention. It's going to give a brief description of the drawings. It's going to describe the preferred invite, and then it's going to show you your claims. So claims are really, really important. And I am giving you a little bit of a thing. So before I go into claims, I just kind of want to show you examples. So this is what a background of an invention description is going to look like. And then this is kind of the summary. So as you can tell, summary is a little bit longer than the abstract, not quite as long as the background of the invention itself. Here's the description. So as you can tell, these are the numbers that are cited. So it gives reference to each figure of your drawings and diagrams. This is the description of your diagram. So it gives you more sites with those numbers. And then, we go into your claims. So your claims are really important because they're going to distinguish what exactly can be developed or created around your invention, as well as they're going to make sure that your claims fit and don't infringe on others. So a lot of times when people see something that's similar to their invention, they really want to look at the claims of those side references because you don't want to write your claims too broad to which people can wiggle inside those claims and create other things that are very, very similar. But you don't want to write your claims so narrow as to which so many people can create way more around you and better your invention, and you put yourself in this little bubble. So it's all about balance. It really is. And like reading other people's claims, this is going to help you in writing yours because when you look at those claims of those other inventions that might be similar to yours, you're going to see, okay, I'm reading through it. Okay, well, mine is different because it has this aspect. And that's how you distinguish yourself in between those claims. But you want to make sure when you're writing your own that other people can't come into those little areas. So it's really kind of a process. That's why I recommend those brochures and those NOLA Press books at the very beginning of this presentation because it is a process. It does take time. And a lot of people like to look at multiple examples and such outside of just patent applications. And this is a good way to kind of get that. So next I want to talk a little bit about the patent process itself. So we talked about the definition of a patent. We talked about the criteria, what falls beyond that. And then we talked about what exactly step-by-step the application processes look like. We also talked a little bit about where to go for search strategies, which I'm hoping to have a little bit of time at the end to kind of show you an example of what some of those databases look like. So next up, I want to talk about the patent process itself. So let's say you've got an invention, you've decided what it is, you've gone through the criteria, you know it's new and novel, you have distinguished the difference through your prior art, you've done your research and stuff, you're ready to go through this continuation. So a couple things to kind of keep in mind is there is a first to file. So this is in relation to American Inventors Act that was created in 2011. And it's the first to file versus the first to invent. So at least one claim not covered by prior art or disclosure, and there is a public disclosure exception. For US, our exception is a 1-year window. So I'll kind of talk a little bit more about that in the next couple slides. But this is just kind of the brief introduction. And then also, you do have the potential to apply for a provisional patent application. So this is a way to help inventors get an application in sooner because it requires less information. So let's say that you're in the process of filing for a patent before somebody else does. You know, maybe there's some sort of conflict or something, and you're like, I'm really trying to get this out. I'm trying to, you know, be the first to file. So you choose to do a provisional first to give you a little bit of a more window. So non-provisional patent applications, they must be filed within a year of the provisional, and they must represent the same invention and claims. So a good way to explain provisional patent applications is it's kind of like a rough draft. It is your patent application, but it may not be your patent application to the fullest extent. So if you're looking to really get your patent in, but maybe you need a little bit of extra time, so you choose to do provisional, what you will do is you will do your application. It won't necessarily require extensive amount of all the information, but will require, you know, your basic claims, your abstracts, and so forth. You file, let's say tomorrow. So you have exactly 1 year from tomorrow to get your normal patent application through. Now, let's say you turn in your regular application not on the 29th, which is today, but the 30th. It doesn't count. It won't apply. You have to do it by the 29th, exactly a year. Otherwise, that provisional goes out the window. It's not counted, and you don't get that extra date. A lot of people do this provisional to get that earlier filing date once they've done the 1 year window and they've applied for a normal patent application. Like it says before, it does have to be the same. So you can't just do a provisional patent application and have one invention and it have all these claims and then do another and it be a completely new invention. It has to be the same, and it has to have the same claims. Now the claims may be rewritten to mean the same thing, but it's still, they need to be the same. So that's something that a lot of people do like to do because they like to have that earlier time frame. Also, it's not something they look at. So once you apply for a provisional patent, we like to use the example, it basically kind of goes in imaginary filing cabinet. Nobody looks at it for a year. Let's say you get your new application, your non-provisional turned in. Okay, they go to that file, they pull out your provisional, and then they look at it. And they look, okay, this is the same invention, this is the same claims. Okay, let's continue to move forward. And then they, you know, dive deep into it. And if it's granted, then you get that earlier filing date. If for some reason it's not the same, or it's not granted, then that's where the provisional wouldn't take place. Or if you failed to do it within the year window. So it's kind of a business decision whether you want to do a provisional before doing your non-provisional or if you just want to move forward. But we do get quite a bit of questions in regards to provisional patents. So I like to dive a little deeper into it. So next I want to talk about post-disclosures. I talked about that 1 year window in the past slide and the first to file. So this is kind of where that comes into play. So you really want to be careful in regards to public disclosure. So this is what it can include. Going to a trade show, displaying your invention online, displaying it in public at an event, writing about it for publication, or discussing it without an NDA. What exactly is an NDA? Is a non-disclosure agreement. This should be legal binding, be effective. Some people, they create their own non-disclosure agreements. Some contact an attorney to have one created. I've seen lots of different ones. And not likely to be signed by a larger corporation or investors. So if you have to talk about your invention before applying for a patent, you want to be vague. In my case, my consultations are solely private. It doesn't go beyond me unless I'm requiring a question from the USPTO itself for you. So in that case, I've been where I've signed on disclosure agreements, or I've had people that have asked me a question and they've just chosen to be vague, and I respect that. And it's the same with any other PTRC or when you're talking with the USPTO themselves. But when you're talking with other people, you know, just casually sharing something or whatnot, want to be careful of this because if you do publicly disclose in any of these forms, and it can also be maybe you do a blog or maybe you did a YouTube video or such, then that can put you in that 1 year window, and it can make it harder for you to get a patent potentially. So what exactly is that 1 year window? So inventors who create prior art by disclosing cannot invalidate their own patent application as long as the disclosure is within a year of the filing. So if you are one that you have an invention or you're creating something and you've shared it, then you may fall within that 1 year window. I have known people that this can happen where they accidentally disclose something at a trade show and then they realize, oh no, when they're finally ready to do their patent application, they disclose and their 1 year window has passed or such. Public disclosure, there's risky because someone else could file first, claiming inventorship or stealing your idea. Foreign countries, they don't have a 1 year window. So for their applications, there should be no public disclosure at all before patent application is filed in the country. There is an exception with Japan, but excuse me. But that's something to note if you're looking at foreign applications as well. They don't give that 1 year window. We at least do, but that's something that can create problems, but it's also good to know, especially if you're in early stages. So best advice is just to be vague when sharing or talking about your invention until you're ready to take it to that next step, especially if you're wanting to get it patented. So how will you file? Is another question. So let's say you've been vague, you've been good to go, you're ready to file, you know, done your research, you have your prior art. Okay, how do I want to file? There's a couple different ways. So patent applications, they are difficult. But I mean, some people, they do it on their own. Some people seek out help. There's lots of different ways you can go. I will say it is probably the hardest application of all forms of intellectual property, but it is not impossible. So like I said before, there are multiple options. So one option is to go through a patent attorney or agent. I do know for Kansas, I believe last I checked, there were 4. There were 4 people. That might be different since COVID, but if you go to the USPTO website, you can look at legal assistance and type in your city or your state and see what patent attorneys or agents are nearby. If it's a quick question you're wanting to seek out, then you'll most likely be okay. If it's, you know, you're wanting to ask them a more in-depth question, they might ask for a meeting. And then if you're wanting to utilize their help, obviously you're going to need to schedule things. So, other things that you might look at are apply for pro bono assistance. So for pro bono assistance, there's 3 things that you have to consider when potentially wanting to apply. 1, does your income fall less than 3 times the federal poverty level? Also, can you demonstrate knowledge of the patent system? This can be done of 1 of 2 ways. Maybe you've already applied for a provisional, but you need help doing the actual application. Maybe you choose to watch their videos and sign a form saying you've watched all of them and you now understand how the patent system works. And then thirdly, there is to describe features of the invention and how it works. So this, you would need to describe your invention and you would describe how it would work. If you can do those last 2 things and you do fall within the income of less than 3 times the poverty level, and they do provide a chart for you, so you can tell if you do apply or not, then you can apply for pro bono assistance. This is going to be free legal assistance. So if attorney is way out of your price range, but you know you need help, if you can fall within these guidelines, this is a great resource. If, let's say, you don't fall within those, then there is a couple other options. So you can apply for the law school clinic assistance. These clinics may serve a state, a region, or all of the U.S. Kansas does not have a specific law school clinic. I wish Washburn did, but they don't. So for us, you're going to look at all the law schools on that list that USPTO provides and go to any that say that they help all the U.S. or all Midwestern states. And you're going to want to make sure that they either help not only patent and trademark, or they help just patents, because you don't want to pick a law school that only helps trademarks when you're needing a patent application help. With the law school clinic, it is free, but there are a couple fees that do apply, such as the application fee itself. But this is a great alternative for people that, again, if attorney is way out of their price range and they make too much for pro bono, this is a good alternative. The nice thing about it is I kind of feel like you're getting multiple eyes. So I like that because it's not only the law school that looks and helps, like the law school clinic patent attorneys there, but they're also helping their students. They're teaching their students how to, become patent attorneys, and they're getting that extra help, but they're also overseeing it. So you're gaining an actual patent lawyer or attorney's help. And then you're getting, obviously, the USPTO to look at it to grant you your application. So it's kind of like a triple I effect. And then lastly, you can file pro se. So this is without legal assistance. For this, you would either just visit USPTO for information. They do have videos and tutorials. They do provide an application checklist, such as the application that I had shown you prior, just kind of the step-by-step, this is all that you need on your application. Other things that you can do is find brochures, books at the library. So like I said, we have brochures that the USPTO sends to us, and we have them on all different types of patents, how to file, all these different things. This is also when you would utilize us. We're not lawyers, we can't give legal assistance, so we can't be there for you when applying, but if you're needing help navigating the database systems to look at prior art searching, or you're wanting to kind of feel out where are the steps you need to go, this is kind of where we kind of come into play. You can also check out our books, like I had mentioned. Those NOLA Press books are wonderful. Couldn't speak highly enough about them. But you can also look at other books. There's multiple. We have a whole collection up on the 3rd floor that are in the K sections. So this is kind of your options in regards to how you would file. There are discounts for applicants. So there's two different types. There's small entity and then there's micro entity. So these discounts are a little different from how to file. So with small entity, this is going to be mostly an individual. Maybe there's a university aspect. It could be nonprofit organization or business owner with less than 500 employees. So small business, like Kansas Small Business Development Center. This could, pertain to their clients. Micro entity is going to be, you qualify as a small entity, but you also are an applicant that hasn't been named as an inventor on more than 4 patents. This is any type of patent. And then also your gross income is less than 3 times the national median or majority of income that's from the Higher Learning Institute. And they do have a chart again for this. So these are more ways that you could save, especially down the road, because there are maintenance fees that do apply with patent applications. And I'll talk a little bit about that when I get to the application fees. So what now I want to talk about next is kind of working with the patent examiners. So USPTO committees happen through your attorney if you have one. So once you've filed your file, whether it's provisional, if it's provisional, it'll go in a filing thing, they'll wait a year and then they'll pull it back out. But once you've hit that non-provisional or you've hit that timeline, they'll take out one or both. and you're going to have a patent examiner looking at it. They're the ones that they're going to look at all your prior art. They're going to look at their own. They're going to make sure that you've done all the right steps. They're going to make sure that you don't need to fix anything. And if you do, this is what they're going to do. So if you seek lawyer help, they're most likely going to go through your attorney. They might ask you to be a part of the conversation. Your attorney will probably see where you want to go with this, if you still want to continue the process, and so forth. Now, they do send office actions, and non-final rejection happens very frequently. So if you get a letter, we've had a lot of people that come and they're like, oh, I got an office action, like my patent is failed, like there's no, that's not what that means. It means that you need to respond quickly to avoid extensions. So most likely in terms of office actions or non-final rejections, this means that maybe you wrote your claims a way that they didn't like or that you need to fix. Maybe you didn't list enough prior art searching, or they found a couple typo, just it could be anything. They send you an office action. If you work with an attorney, this is where that will come into play. If you're on your own, this is what you will receive. And you basically need to respond quickly. They normally give you a window, so patent pendency, about 16 months until first office action, 2 years for full process. So that varies right now because of COVID. I'm not quite sure where they are on their timelines, but normally it does take a while for patent applications to go through. Office actions are what's going to prolong your application process. And in this case, this is where that full 2 years will come into play. If you have a lot of office actions and you don't respond quick enough, it can take years before your patents get granted. So that's why you want to respond quickly. Also, if you don't respond in a timely manner to office actions, they can decide not to grant you a patent because your window has closed. And that's why you'll see some patents have, they don't have the live, they have the dead symbol on there when you're doing your searching, because maybe they failed to pay a maintenance fee or they failed to do an office action and they just let their patent application not go forth. So next I want to talk about patent fees. And I notice I'm getting quickly through this, so I'll be able to show you the examples like I have planned. So with application fees, this is a chart that's going to kind of go over everything we've talked about within the last few slides. So this is prevalent to as of 2018. It really hasn't changed much over the past few years. So I'm sticking with this chart for now until they give us a better updated. But this is what it's going to look like if you are applying for a provisional or a regular. So obviously you can see what regular costs are. And then you can also see what small entity or micro. So obviously if you qualify for micro, you're going to be paying the lesser fees and it could save you a lot. Small entity is kind of your middle ground, and then regular cost is going to be your most expensive. Now, these are just the fees up top. So this is your fee for if you choose to do a provisional before doing your regular, and then once you choose to do your regular. So if you, let's say you do a provisional and then you do your regular application, you're looking at $580 if you're doing regular cost. There can sometimes be a search fee or examination fee that come into play. Then you're looking at priority. Those, it kind of varies depending on which route you take in terms of assistance, non-assistance. Then there's the issue fee, and then there's maintenance fees. So I talked a little bit briefly, I mentioned it in terms of maintenance fees. I also at the very beginning mentioned how there's terms that each patent's lifespan is. So with utility and plant, you have a 20-year lifespan, and with design, you have a 15. So within those, once your patent gets granted, you have 15 to 20 years before it expires. Now, once it expires, it's the notion that you built up that patent invention well enough that nothing else could maybe come in, or you've made enough money off of it that it may not matter as much, but you can't just fill out another one once it's expired. You only get a 1-year window. With those terms, throughout that time, to keep it, to keep your patent live and valid, you have to pay maintenance fees. Each maintenance fee does go up. As you can tell, it goes by 3 years, 7 years, and 11. And it can range from 400, 800, 116. It can range from 9 to 18 to 36,000. It just kind of depends on your entity. But it also goes up each year because it's with the notion that your invention is making money. A lot of times, this is another reason why you can see a patent application is dead earlier lifespan. Maybe that inventor created something that it was going really well. He was making a lot of money of it. When it came to the 3.5 year, he decided to pay the maintenance fee, continue to make money off of it. Well, somewhere around year 5, it went downhill and his invention stopped making money. So when 7.5 years came around, he was like, and he's in micro entity. So that 900 just didn't seem worth it to keep it around. He kind of quit his side business. So that's sometimes why you'll see maintenance fees kind of just stop and plummet. So next, I kind of want to give you guys, since I have a lot of extra time, I want to give you guys a thorough into some of these resources. So like I mentioned at the very beginning, I've created research guides for you guys. So this is, we have a patent, trademark, and copyright guide that I've created. It also has tabs to which you will see just patent information, trademark information, copyright. So if you're looking for one specific form of IP, you can go there and it'll show you just a whole list of examples, materials, lots of things. And then we used to do this entrepreneurship research series, or free workshops. This semester and last semester, we've kind of put them on hold just because of COVID, and we're still trying to figure out how to reach as many people. And we've got new people coming in, so we're waiting. But we have provided all of our PowerPoint slides, including this one I'm doing today, on that site link so that you can see what workshops we would have been providing. You can at least see the slides, make notes for yourself. If there's something of interest on those slides you want to discuss with me or one of the other librarians that puts on that series, you can kind of go through that with us. So I am going to now share a different window of my screen. And that way I can show you a little bit in depth. I want to give you guys a visual of what exactly our USPTO website and what exactly our library website kind of looks like, so you guys have a better feel of the information. So if you go to uspto.gov, this is USPTO's main website. So if you're looking for any forms of IP, whether it be patents, trademarks, copyrights, I'm going to focus mostly on patents, but this is where you're going to go for that assistance. This is like the headquarters assistance. So for this case, I'm going to talk about patents and kind of go over some of the tabs that we discussed in this presentation. So I like to go find it fast. I feel like that's way easier. So PatFT, this is going to be a database system. So when you're ready to do that prior art searching and you want to look at other patents that are prevalent and that have been filed within the US, this is where you're going to go. You can type in whatever you think is going to describe your invention. You also, it's kind of a synonym game in a way, because you want to not only think about what your invention is, let's say it's a standing desk, but you also want to think about what else you can call that. Maybe it's an adjacent standing desk. Maybe it's a standing desk on wheels. You want to think about every aspect and type those in and see what pops up. Another thing that's important is to pay the maintenance fees, like I said. So this is where you can click and go to pay maintenance fees. You can look at the maintenance fees charts. Here's another segment that goes more in depth into the fees and payments. So this is where you would go for that. If you go up here to the more thorough, they do have a lot of tutorials, a lot of information in regards to all different types of patent applications, the overview, everything. If you go here to legal assistance, this is where you can go for that chart to see if you fall within the guideline of that poverty level to get pro se assistance. This is where you can also go to find a patent practitioner. You can find a law school that works for you. This is where you can go to locate a PTRC. Luckily, you've already found me, but this is where you would go for all that information. And it's going to be, and I will put this in the chat. Let's see. It's going to be uspto.gov. So that's where you would go for all of that information. Next, I want to take you guys to the library website. So this is our library website, and this is where you can go to find me. So I'm going to type our site in for you. Wichita is libraries.wichita.edu. If you want to go specifically to my guide, you would just go /PTRC, but I will also show you. So we've got lots of information. Our library hours, so we are open to the public right now. We're not having all of our floors open. So there are a couple floors that are closed. It is our basement and third floor. If there are books that you're wanting that are in that area, such as our PTRC material books on the third floor, what you would need to do is search for them and then request that a staff member bring them down for you. They're more than happy to do that. And anybody can become a community user. If you're alumni, it's a little easier to create a profile for you because you're already in the system. But if you're not, you just bring a couple forms of ID and mail and social security, and then we can get you all set up. But if you go here to this last tab of research guides and you go to subjects, you'll see a whole list that will show up, and you want to go to patents, trademark, and copyright. So this is where I am. You can see a little photo of me. I have a little link. So this does take you to my Zoom. If you are wanting to meet with me, you've got questions, have a consultation. Let's say you want to email me with a specific question and then maybe try to find a Zoom time that would work for us. There's my little link as well. I do have a phone number, but because we are working mostly remote or hybrid these days, I've chosen to take it off just because I don't get to check my email as often as I'd like, or my phone as often as I'd like. And I want to make sure I can get to you guys' questions as soon as possible. So I do provide 4 different guides. So one specific to copyright, one specific to trademarks, and one specific to patents. This is my overall one. So if you're looking for just all different types of IP, or maybe you found, you are wanting to apply for a patent, but you also are maybe looking at trademark as well, that's kind of where you would start out. But I'm going to take you through patents. So this is going to show you how to get started. It's going to take you through the basics that I talked about today. It's going to show you that in-depth patent searching like I had shown before. Whether you want to do Google patents, whether you want to go through USPTO. It's going to show you other databases that you can look for. Legal assistance as well, how to apply for a patent. These are those books that I had talked about. So we have brochures that not only do we have physically in person, but we also have links to them. And then these are those books. So if there's one that really speaks to you, you can go to our front desk and ask and request for those. Let's say you are a new inventor and you're just starting out, and once you've reached that stage of you filed for an application and everything, and you're ready to move forward and stuff, maybe you want to look at inventors organizations. So this is a tab for that you can go and kind of learn to network with those people. Inventors Association of South Central Kansas, Isaac, they're great. And I know that there's doing Zoom meetings still once a month. So they're a good resource to get in contact with. Like I said before, we do have that entrepreneurship series. We're not doing as much right now. And we're kind of taking a break, but hopefully we'll come full back in gear in the fall. But if you go to our entrepreneurship research series guide and you click on patents, trademark, and copyright, here are all those guides. This one, Patent Basics, is the one I'm giving today. So if you lose your slides or lose the email link that Marcia have provided, you can come here to look at that. If you're curious about the other workshops I provide, here are those as well. Lastly, another thing I wanted to kind of take you through is I want to show you what Google Patents looks like as well. So this is what it would look like if you were going to Google Patents. Just another form, and I will type that in as well. Google.com. Oh, well, I did not mean to do that. So for this, it's going to be just like USPTO. The only difference is Google Patents, they do not only show you regular, but they also show you foreign. I do want to give you that example of if you were to use them over USPTO, you will find down at the bottom or on the side in this case, you see those charts. And then for USPTO, if you are on their website and you type in the same thing, standing desk, it will show in this diagram. So it's just two different forms. Obviously, you're going to have more results on Google Patents because Google Patents is not only looking at US, but it's also looking at foreign. And theirs looks just more like a Google search. They have one tab, not two. And this is where you would go to add in extra filters. For USPTO, you have two options, and then this is just kind of shows you, and you have to click to see the examples. So those are just a more in-depth view. I like to use standing desk because it's a little simpler. But yeah, and then that is all. I got done a lot quicker than I planned, but that's good because I see a couple questions have popped up in chat. And I know that with patents, questions can be pretty intensive. So Haley, it looks like you had a couple questions on chat. One in relation to how strict are they about non-obvious? Let's see. Yeah, seems like an obvious solution, but is not on the market. Non-obvious, it's gonna vary, honestly. It's on looking at criteria, the biggest thing that they're gonna be looking at is the novel and new. Non-obvious though is important, not to say that it isn't, and obviously like all the other criteria features are important. But yeah, that is something to be considerate about. You're not just thinking like, you know, something can look obvious to you, but the person next to you, it may not look obvious. And so you got to keep that in mind when you're looking at your own criteria. Just like in the terms of new or novel, you might think it's new, but somebody else might not. And that's really where that prior art searching comes into play, because when you are searching for your own invention, like you are probably in that stage, I would assume, where where to you think it's not obvious, so you're going to do that searching. As you're looking and seeing similar aspects to your invention, and you're seeing, okay, like this is how that application does this invention is similar to mine, but this is how mine is different, and you're proving that, that's going to be kind of where you're going to figure out, okay, is it really non-obvious, or is it just, you know, non-obvious to me or obvious to me? Let's see. You also asked another question, just to confirm, being vague. Yes, so being vague. Specifics trying to sell. So I know you asked about provisional applications and if you still need to be vague past the provisional. It's still good to be vague. Even now, obviously, like this is a good idea when non-disclosure should really come into place. Sorry, when non-disclosure should really come into play. Because, you know, there are people that they want to get going, they want to kind of start, but they need to get patented. And, you know, when you're going to invest or something starting to sell, you know, there's that race to, you want to start doing this, but you really want to take your time and make sure that there's those steps to making sure it's granted before you fully disclose, because even after doing that provisional, that's not your actual application still. So you still need to figure that out before your application is filed, and it needs to get approved first. It would really kind of depend on who you're choosing to disclose to. Past that, I know you mentioned trying to sell the product. You really want to try to get marketed before, but you really do want to make sure that you're not overly disclosing and then messing up your thing. Also, you got to remember, between a provisional and a regular, you only have that 1 year window. So it is a long time, but it also isn't a long time. So that's kind of one of those you would probably want to really tread lightly still. The best example I can give to which this becomes an issue sometimes is a lot of people like on Shark Tank or other like trade shows and things, they think that they've filed when they really haven't yet, and then they've accidentally publicly disclosed too much, and because it was on a TV show or it was out in public, then they've you know, lost their window frame. Now obviously, like if you've kept it vague leading up into your provisional and you do your, you know, there is that, okay, is this in the 1 year window? But that's one of those you would really want to seek probably a lawyer's opinion on, depending on who you're wanting, how you're wanting to share your information, who you're wanting to share it with, and how less vague you're wanting to be. Just because I can't give you that full legal advice. And then let's see. See if there's any other questions. I see another one. What is the difference between filing an invention disclosure form and filing for a patent? I assume with the filing invention disclosure, you're talking about a non-disclosure agreement form. Is that correct? In terms of that, so filing for a patent, you're doing a full patent application. So this is, you know, your invention is new and novel. It's, you know, have a non-obvious composure method to it. You know, it's something new. You're actually like filing to get that approved so that nobody can create anything like your invention. Nobody can infringe on it. When you're wanting to file an invention disclosure form, I'm assuming you're meaning non-disclosure form. So non-disclosure form is not something you file with the USPTO. Non-disclosure form is something that you create yourself, maybe with the help of an attorney. Maybe you look at other non-disclosure form, or you create your own. And in terms of non-disclosure form, that's something that you would have somebody that you're talking with potentially sign before filing for a patent. So I've had people that they want to consultate with me, and they will sometimes they don't want to disclose too much to me, even though I can't say anything because I work for under the USPTO, but they want to take that extra precaution, so they'll choose to have me sign a non-disclosure agreement. I've had in some cases people are doing like a work for hire, like maybe they've created an invention but they need help with somebody doing the drawings or something, so they do a work for hire situation and they'll have them sign a non-disclosure form. So that's something completely different from filing for a patent. Okay, and then I saw you mentioned you worked with Rob Gerlach. Okay, but it seems it went nowhere. Okay. Oh, and not an NDA. Okay. Well, beyond that, I'm not quite sure what you're talking about in terms of filing invention disclosure form. The only thing I could think of is if you were working with Rob Gerlach, that could be a university thing. So Rob Gerlach, for those of you that don't know, he is WSU's patent attorney on campus. He works with WSU Ventures, and his department area is a little different from mine because I work solely with the USPTO and for the USPTO and PTRC, as well as WSU, and he works solely for WSU. So his thing is he works with a lot of students, sometimes clientele, and will work to sometimes create patents with students through the university. So in regards to filing inventions disclosures form, that might be something that maybe he does with the university program, Gateway to IP, that I'm not as familiar with because it's a different component. And I'm sorry that working with him didn't seem to go anywhere. You are welcome to contact me and see if it's something that I can help you with, or if it's something that PTRC and USPTO can help you with. I know that Rob, he tends to only work with WSU related matters. So if it's something outside of WSU, or it's something that you're wanting to take independently or on your own, then sometimes he may not be the right person, and that's kind of where I come into play. So yes, I will give you guys my email, and I know Marsha will probably give it out as well. I will mention that my email will most likely change in the next couple of weeks. Since getting married and changing my name, I'm still working to change it. So for right now, use the Jessica Torres, but just know probably in about 2 weeks, it'll change to Jessica Pierpoint. So depending on when you want to contact me, I would say try to contact me sooner rather than later, so I can make sure I can continue to work with you past this workshop. And then Haley, I know she asked another question about how long does it typically take to get approval for a provisional. So provisional, like I said, it's kind of like a rough draft in a sense. So it does not get, even though you have to file it, and once it gets filed, you have that 1 year date from when it was exactly filed. They don't look at it. They don't look at it until they get that non-provisional. And we do have some people that they've come in and they're like, well, I did a provisional, but I never did a non-provisional. Well, you have to do the non-provisional, because if you don't do it, then your provisional, it never gets looked at. So, sorry. So it never gets to move forward. So with that, provisional, it's not so much it gets approved. It's more of you need to fill out your non-provisional version next. And you have 1 year to do that. So like, let's say you were to do it today, you have a year until today. And then once you do that, that's when it starts to move along in the process. They'll start to look at it. They'll start to see if you have office actions. Once that gets taken care of, if you have any, then eventually once you get your filing date approved, then they'll backdate it a year and you'll get that earlier provisional. Mentioned 2 years generally for regular and with only having needing to, yeah. So provisional and non-provisional, whether you choose to do provisional or you choose just to do non-provisional, it doesn't really make it go any faster or slower, because they're still looking at the same information at the same time. They're not looking at it any sooner, because even though you've submitted that provisional, they're not going to look at it until you submit your non-provisional. So it doesn't help the process move any faster. The only thing it does help is your filing date. It gives you that 1 year earlier filing date, which to some people that is really important. And as for like the 2 years, it can take that long, but it can also take less time. I mean, maybe you did your provisional, you did your non in less than a year, and you didn't have any office action, or maybe you had one minor small one and you responded really quickly. It could take less. It very much varies, and it also depends on if you're having help, if you're not having help. There's a lot of variables to that. So that's just like a guesstimate or like a generalization, but I can't pinpoint it for you specifically. So I hope that clarifies your questions a little bit more for both of you and all of your questions, and you're welcome. If you guys have, we still have 15 more minutes, and I'm glad I'm able to get through all your questions. So if you guys have any more questions you want to kind of type in the chat or speak out about, you're welcome to. Like I mentioned, I put in my email, and I listed uspto.gov, Google Patents. I mentioned the library website. If you go to the library website, my contact information is also there. Don't hesitate to contact me if you want to consult or if you have additional questions past this. So yeah, if you guys have any more questions, send them in. Otherwise, we'll get to be done a little earlier.